and certainly the attorneys, the representatives, and then you would have the accused there.
The bench book says that.
That's correct. But my lord, in that situation, because it was a situation within the transcript which reflects that it was actually a conversation between one of the appellants and the son of the jury. She didn't actually see or confronted the appellant. And so she was concerned, so she only heard information, and the inquiry didn't go as far as to find out the truth of that inquiry. And so it led to a discharge. What follows from that is the opportunity would have been lost for the appellants, if questioned, or to say, well, this is not true, and then the judge would have made an informed decision. What follows from that also is that the foreman, she was a part of the questioning. She was then asked if she was allowed to, if she could continue. She says, I'm only worried about the safety of the juror number 11. And she leaves knowing the information, and it's fresh in her mind and remains in her mind. We have no way of knowing but to speculate how much conversations outside of that would have gone to the other jurors. Then, moving back to the next inquiry number 3, it is the same forewoman, and more conversations about her role, and so the taint or the poison would have gone back as far as November in a 65-day trial and before juror number 11 left. So a proper inquiry could have found out, especially in a space where we do not know at what point or if any, when it is exactly the responses, or if the other jurors could have said that that wasn't the case at the time, if a proper inquiry and asking each and every juror, not even suggesting that it be done on the oath, but if it was asked, what their responses would have been for the judge to make an informed decision. And I say this in the context that, in light of the fact that our Constitution, it places even a duty on the judge to, as the custos morum of the Constitution, to protect the rights of the appellants, that it was incumbent on him to ensure that he makes the inquiry so he protects the fair trial right. So that would be in response to your question as it connects. So what flows from that then is when we get to the late retirement, we have a juror who is the fruit of the poisonous tree, or the introduction of the poison, no knowledge of how far the poison is. I'm not inviting the court to speculate, but that's all we are left to do, respectfully. And what happens in that situation is we don't know if the pressure arises because there was a situation where these jurors were able to say, I would participate in a bribe, allegedly, or not. And so the verdict that comes could never be a true verdict in light of that. So that's the submission as it connects from incident 2 to incident 3. Now, in relation to the proviso, and I think you had knocked some of the wind out of me, say, Lord Reed, because I would have borrowed your words in the judgment to say that you can't proviso unfairness, you can't proviso unjust. It's just not possible. It would be an absurdity in the law. Now, in relation to Lady Simler, you asked a question about the balancing of rights, the balancing exercise. I would submit to you that the Jamaican Constitution, in particular the Charter, it came at a time post the Phipps decision. So there was a lot said about King and certainly Phipps, the Phipps judgment. But at that time, it was presumption of constitutionality, and certainly the onus was on the appellant, to prove the privacy right violation. Post the judgment in Phipps, our legislators, which our parliament certainly has that ability to represent the people, and they would have thought that as a matter of public interest, the very right, the charter rights, in particular the communication rights, which is for all, the least among us has that right, was to be protected in such a way that where there is a breach of that right, it's a distinct difference. What difference is that? Lady Simno would have asked, is that the judge now has a duty to carry out the Oakes test or the demonstrably justifiable test, because somebody says, and in response to Lord Reed, but the appellants are not here to complain of that right. But they did at first instance to their counsels collectively. And at that basic complaint about the right follows that the judge is to call upon the prosecutor to say that it is demonstrably justified because there is no issue before this court that there was a breach. The effect of the breach or the balancing exercise can only begin after the prosecutor has met the burden of demonstrably justifiable.
Can I ask Mr. Buchanan, while you're addressing us on the Charter, as I understand it, the Charter is formally, is part of a constitution. It was made part of a constitution by a constitutional amendment in 2011.
That is
right?
Correct.
Was it preceded by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
But right.
What is significant?
Check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this. And I'm quoting, I'm paraphrasing our Chief Justice, and it's found. Thank you. It's found in the written case at 12 and 13. Yes.
Right. Thank you.
Yes. But what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us. It was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society. Yes. Is the importance of protecting the least among us.
And was it intended that it be developed, I suppose, was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of circumstances in Jamaica, or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21. Yep. But what's significant is that what is clear is that there is, similar to in the Canadian jurisdiction, that the test, which is the demonstrably justifiable test, is mandatory once once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislators.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us, rather than imposed from outside.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b, it is the last flicker or shimmer of light to what it is to be a human. Yep. And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it. Yeah. So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time, or
you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland who would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, the Lords and the lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned is tainted was allowed to remain on a jury to bring a verdict simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror